telephone solicitations. Now, a telephone solicitation, which I'm sure most of you know and love getting, are defined as the initiation of a telephone call for the purpose of encouraging the purchase of or the investment in property, goods, or services. Thankfully, though, they have the National Telephone Consumer Protection Act, or the Telephone Consumer Protection Act, which established a national do-not-call registry for consumers who wish to avoid such calls. Now, consumers at no charge may request to be on this list. Telemarketers are supposed to go through this registry first before they make any calls. Calls are supposed to be restricted to between the hours of 8 a.m. and 9 p.m. Those are important dates and times to remember. And if you violate the federal do not call list, you can be fined a little fine of $16,000, not for breaking it, but for every single call that you did while breaking it. State regulation. So that was the federal. Now we're going to move on to what the state of Florida says. Now, Florida also has a telemarketing law, and it is administered through the Department of Agriculture and Consumer Services. Florida also maintains a do not call list also. Now, Florida has made its registry part of the national do not call list, and if you violate Florida's rules, you can be fined $10,000 per call. They're a little more lenient. Now, a major difference between state and federal telemarketing laws is that Florida law says it's cool, you can call someone that has a for sale sign in their yard. However, the federal law says no. And of course, when it comes to state versus federal law on a specific item, the federal law wins. Now, the Federal Communications Commission, that's the FCC, recently ruled that under the federal law, real estate sales associates are not allowed to call a for sale by owner or homeowners that have expired listings to solicit for a listing of their property if their names are on the registry, even if their numbers appear in a yard sign or a newspaper advertisement. Now, the federal law does, thankfully, provide 3 exceptions, and they are as follows. Number 1, a sales associate representing a potential buyer may call the for sale by owner seller, but only if they have an actual buyer that's interested in the property and you want to call them to negotiate a sale. Number 2, the sales associate may contact individuals with whom the sales associate has had an established business relationship already, even if their numbers are on the registry. For example, the company that previously listed a property may contact their former customer to solicit new business for no more than a year and a half or 18 months after their business transaction has concluded. The third and final one says sales associates are allowed to contact any customers after 3 months of an inquiry or an application, such as a customer who registered at an open house or a seller that called and requested any information from a sales associate and you are returning their call. Now, if a sales associate calls a for sale by owner or an expired listing under the exceptions listed above, and the homeowner requests that you don't call them, then, well, you comply. Telemarketers must state their names, their business name, and the business telephone number. Telemarketers may not block their phone numbers, period. Businesses that use telemarketing must develop and adhere to written procedures regarding the firm's calling policies. Businesses must advise and train their personnel and independent contractors engaged in telephone solicitation regarding these do-not-call maintenance and procedures. Real estate companies that wish to use telemarketing in their business strategy, which most do, must obtain a list of phone numbers in the registry, Licensees are supposed to go through this registry at least quarterly and then delete from their call lists the phone numbers of consumers who have been registered. Now, sales associates, beware. Even though the state law exempts real estate licensees for the purpose of soliciting for listings, the federal law does not. So do not end up in federal court. Make sure you check the registry first for all numbers if you're doing any telemarketing business.